As you are aware, a lease is a legally binding agreement. For this reason, we at Full Service Property Management want to be sure that you fully understand the terms of the lease before the lease is fully executed or signed by all parties. Please view this video in its entirety, as it will clarify many common questions related to the lease. We also ask that you contact Full Service Property Management if you have further questions. Contact information will be provided at the end of the video. We have done our best to construct this video in the order that the lease is written. However, you may find that items are out of order in some cases, as a new lease is drawn up by the attorneys for each property. We have also strived to describe and explain all portions of the lease, although some may be described in more detail than others. Keep in mind that we are not attorneys, and Full Service Property Management is in no way providing any type of legal advice. Again, please contact us if you have any questions. The lease begins by describing the parties to the lease and defining them as tenant and landlord. Landlord is the owner of the property. As the management company, we represent landlord and accommodate communication between tenant and landlord. Decisions related to the property are made by landlord. Full Service Property Management proceeds according to landlord's instructions. The term of the lease is then described as the date that the lease begins and the date that it ends. Florida law requires that a lease term for greater than 12 months have 2 witnesses to the signatures. If witnesses are necessary, there will be spaces for witness signatures on the signature page of the lease. Keep in mind that the witnesses must actually see the individual sign the lease. In the next section, the occupants are described and include the names of the people who have permission to live in the property. Anytime that someone will be staying at the property for longer than 72 hours, please be sure to submit a written request for permission to Full Service Property Management. Sending us an email will work well. Landlords are not typically opposed to having visitors, but we must be sure that they are only there to visit and do not become permanent residents. Prorated rent will be described in the instance that the first payment period is less than 1 month. For example, if the lease begins on the 8th of the month, tenants would not pay for the first 7 days of the month. The prorated rent is the rent price divided by the number of days in the month and multiplied by the number of days that tenant will have possession. Advance rent is more commonly considered last month's rent. This amount will be 0 unless landlord has required that tenant pay the last month's rent prior to move-in. The security deposit, that will be described later, is not the same as advance rent or last month's rent. As described later, tenant cannot dictate that the security deposit or any part of the security deposit be used to pay rent. The rent section of the lease is extremely important as it describes the rental amount due each month, the date it is due, and where the rent should be delivered. A 4-day grace period is provided before late fees will be assessed. For example, if your rent payment is due on the 1st day of the month, your grace period will extend through the 4th of the month. On the 5th day of the month, a $25 late fee will be assessed. A late fee of $5 per day will be assessed for each day after the 5th until your rent and late fees are paid in full. On occasion, landlord will require a higher or lower late fee, or arrangements may be made for a different due date. Refer to this section of your lease for details on your specific due date and late fees. The first month's rent must be paid in certified funds, such as a money order or cashier's check. Subsequent rent payments may be made by personal check, money order, or cashier's check. Cash will absolutely not be accepted for any payments. If tenant's check is dishonored, bounces, or is sent back from the bank, all future payments must be made by money order or cashier's check. Dishonored checks will also be subject to a fee of $40 or 5% of the amount of the check, whichever is greater. Late payments must be made in the form of a money order or cashier's check. In addition, if rent is not received by the due date, landlord may serve a 3-day notice on the next day or any day thereafter. This notice serves as the beginning of the eviction process and provides tenant with 3 days to pay the rent in full or to vacate the property. All payments will first be applied to any outstanding balances, including late charges. All notices to landlord from tenant must be sent to landlord at the address listed in this section of the lease and must be sent via certified mail. If you are unsure if a particular communication needs to be sent via certified mail, contact Full Service Property Management for guidance. Please understand that all lease signers are equally responsible for fulfilling the terms of the lease, including timely payment of the rent and maintaining the property. Pets are only allowed on the premises with landlord's prior written approval. In addition, a pet addendum must be completed and made part of the lease agreement. No visiting pets are permitted on the premises either. The Florida Landlord-Tenant Act strictly regulates security deposits. There are stringent rules, guidelines, and procedures in place for the management of these funds. Full Service Property Management rigorously follows these guidelines, as the guidelines are constructed with the best interest of all parties in mind. Essentially, a security deposit is both insurance for the landlord and motivation for the tenant to fulfill all the terms, covenants, and conditions of the lease. If these terms, covenants, and conditions are fulfilled by tenant, then the security deposit will be returned to tenant in full when the home is vacated. This is always the outcome that we strive for. However, if any portion of the lease is not fulfilled by tenant, Full Service Property Management will make a claim on the security deposit, or some portion of the deposit, to cover costs or fees landlord incurred due to tenant failure to fulfill the terms of the lease. The claim will be made in accordance with Landlord-Tenant Act, as described in your lease. Tenant is not permitted to sublet the premises or transfer any interest of the property. The lease is between tenant and landlord. This cannot be changed by either party. If one tenant would like to move out or a new tenant move in, notify Full Service Property Management and we will do our best to assist in finding a solution that will be satisfactory to all parties. Tenant has been approved to lease the property based on the information provided in the application. If any information in that application is found to be a misrepresentation, it will be considered a breach of the lease agreement, and landlord may terminate the tenancy. Tenant is not permitted to alter the property in any way. This includes painting and installing fixtures such as lights and/or ceiling fans. If tenant would like to make any alterations to the property, tenant must receive written permission from landlord. Again, contact Full Service Property Management and we will assist in this process. Tenant agrees to maintain the property in a clean and sanitary condition. Full Service Property Management realizes that this is a common sense matter. However, we must stress the importance of cleanliness. We are not expecting perfection. Tenant is living in the premises and hopefully making it home. However, tenant must dispose of garbage in a timely manner and avoid leaving food exposed. This often leads to insect problems that are discovered once tenant vacates the property. The cost of extermination must then be claimed from tenant's security deposit. Regular vacuuming, mopping, and like chores prevent undue wear and tear on the property. Again, preventing claims on a tenant's security deposit. Cleaning expectations and recommendations are described in the resident handbook. Tenant will use the property only for residential, non-business purposes. With that in mind, daycare and/or childcare services shall not be permitted on the premises. Trampolines, athletic equipment, and recreational equipment are not allowed on the property, as these items often interfere with landlord's insurance coverage. If you are interested in such items, please contact Full Service Property Management. We can always ask landlord if their insurance permits such items. Do not bring such items on the property until or unless you have written permission from landlord. Tenant is not allowed to access attics, crawl spaces, or any locked area on the property without prior written permission from landlord. Smoking is not permitted inside the premises under any circumstances. Full Service Property Management and landlord strongly recommend securing insurance for personal property. This is commonly referred to as renter's insurance. It is usually easy to obtain and has a minimal cost. Keep in mind that landlord nor Full Service Property Management are responsible for tenants' personal property under any circumstances. Full Service Property Management is happy to provide contact information for some local insurance agencies upon request. Renter's insurance is also available directly through the larger companies, such as Geico and Progressive. Certain acts, or failure to act, are considered default under the terms of the lease. These items include failure to pay rent as due, violation of the lease, condominium, or homeowners association rules, or neighborhood deed restrictions, failure of tenant to comply with any laws, failure to move into the premises, or abandoning the premises. Upon default, tenant will owe landlord rent and all sums as they become due under the terms of the lease. If tenant abandons the premises or is evicted, landlord may attempt to re-rent the property. Any leasing fee or commission charge incurred by landlord will be tenant's responsibility. In addition, tenant will be responsible for any other fines, fees, or costs that landlord incurs due to tenant's actions or inactions. In an instance where tenants violate or break the terms of the lease, the landlord may need to hire an attorney. If this should happen, tenant is responsible for all costs and attorney's fees, within reason, that the landlord may encounter. In addition, both parties are waiving the right to demand a jury trial involving any legal actions between landlord and tenant. To all parties, please be sure to fulfill all terms and conditions of the lease. Doing so will prevent most issues that may arise during your leasing experience. The utilities section is where parties can look to see what utilities are provided and paid for by landlord. It goes on to explain that tenant is responsible for any and all charges and deposits for all other utilities. Tenant agrees to have all utilities placed in tenant's name immediately, and that the accounts will be kept current throughout the residency. Remember that garbage and/or trash removal are considered a utility according to this lease. Tenant needs to make arrangements for any utilities that are tenant's responsibility to be turned on or transferred into tenant name on the day that the lease begins. Landlord will be terminating service on the day the lease begins for any utilities that tenant is responsible for. Keep in mind that most utility companies are closed on weekends and holidays. Therefore, arrangements for utilities should be made in advance. If you need information on utilities, please let Full Service Property Management know so that we can provide information for contacting the utility companies. Vehicles that are kept on the property must have a current license tag, be owned by tenant, registered, operational, and properly parked. The lease stipulates that no trailers, campers, vehicles on blocks, motorcycles, boats, or commercial vehicles are allowed on the property without prior written permission from the homeowner. Often these items violate rules and regulations of a condo or homeowners association. Having these types of vehicles on the property may also violate town, city, or county ordinances. Tenant is not to repair or disassemble any vehicles on the premises. Any vehicles that violate the above stipulations are considered unauthorized vehicles and will be towed at tenant's expense. Parking of any vehicles on the grass is not allowed without prior written permission from landlord. Landlord is not responsible for any damage to any vehicle that is parked on the premises for any length of time. This section of the lease describes the only vehicle or vehicles that are permitted to park on the property. As stated in a previous section, guests may visit for up to 72 hours without prior permission. However, any vehicle that is on the property as a guest is held to the same requirements as tenant. When signing the lease, tenant is accepting the premises in as-is condition. Tenant is expected to maintain the premises in good, clean, livable condition. Tenant is expected to keep all plumbing fixtures in working order and use all electrical, plumbing, heating, cooling, and appliances in a reasonable manner. Garbage should be kept and removed in a clean, sanitary manner. If tenant or tenant's guests damage the premises in any way, landlord may choose to repair the damage and tenant must pay for the repair immediately. Landlord may also require that tenant repair the damages. This section also defines what items that tenant is responsible for maintaining and repairing at tenant's expense. Common items that tenant is responsible for include, but are not limited to, regularly changing AC filters, maintaining locks and keys, checking and changing smoke detector batteries on a regular basis, notifying full-service property management if smoke detectors are not working once the batteries have been changed, replacing light bulbs as necessary, and handling extermination on the interior and exterior of the home. Often, tenant is also required to handle lawn maintenance and replace refrigerator water filters as necessary. Tenant must also notify landlord in writing, in this case full-service property management, immediately if there is any maintenance or repair need. The work order form is available via our website and should be used to notify full-service property management of any and all maintenance needs. It is also a good idea to follow up with a phone call, especially if the repair is considered an emergency. For information on what is considered an emergency, as well as procedures for work orders, please visit our website. If it is found that plumbing issues are the result of tenant or tenant's guests placing improper items in sinks, drains, or toilets, tenant will be responsible for the fees and charges associated with the repair. Tenant will also be responsible for fees and/or charges if air conditioner and/or heat issues are found to be the result of tenant not replacing the filter on a regular basis. When this lease agreement, or any extension of this lease agreement, expires, tenant is expected to vacate the property and return all keys. This return of possession to landlord must be peaceful and the property must be in good, clean condition with ordinary wear and tear expected. Full-service property management will provide tenant with a checklist to assist with preparing the property for move-out and return of possession to landlord. There will be a charge to tenant if keys are not returned. The amount of the charge will be stated in the lease. Both parties have 30 days prior to the lease expiration date to notify each other of intent not to renew the lease. Put more simply, if tenant or landlord intend to vacate or require vacating at the end of the lease, such notification must be given at least 30 days prior to the end of the lease. If tenant does not provide required notice and vacates at the expiration of the lease, tenant will owe an additional month's rent. If neither party provides the required notice and tenant remains in the property, but no new lease is signed, the tenancy shall become a month-to-month tenancy. In this case, all terms and conditions of the previous lease will remain in effect. The only change will be the required notice, as it becomes a 15-day notice due no later than 15 days prior to the end of any rental period. If this becomes the case, please check with full-service property management to ensure that the proper notice is provided. If tenant does not vacate as of the expiration date of the lease, or any such agreed upon date to follow, tenant will be responsible for double rent from that point forward. Landlord has the right to enter the property at any time for any reason, as long as reasonable notice has been provided. Reasonable notice is generally considered a 24-hour notice provided via phone, hand delivery, or posting on the premises. Should it be necessary for us to enter the property, Full Service Property Management will make every effort to arrange a date and time that is convenient to tenant. We try to provide plenty of notice so that this can be arranged. We do not intend to intrude in tenant's space or violate tenant's privacy. However, there are times when it is necessary for us to enter the premises. Completion of repairs, follow-up on repairs, and general walkthroughs are the most common causes for Full Service Property Management to enter the property. Repair visits will obviously vary. Walkthroughs will likely be performed at the halfway point in the lease term and as requested by landlord. If landlord or tenant choose not to renew a lease, Full Service Property Management will likely begin advertising the property during the last 30 to 60 days of the lease term. This will include the placement of a for rent or for sale sign in the yard. Again, we will do our best not to inconvenience tenant, but we will likely be arranging showings in the home and ask for tenant's assistance in doing so. Tenant may not change the locks on a property without prior written permission from landlord. If such permission is provided, Full Service Property Management must immediately be provided with a key to all locks. Should the property be condemned or deemed unsafe for any reason, or if landlord deems it necessary to accommodate repairs, the lease shall terminate upon 7 days written notice to tenant. Tenant agrees to vacate the premises, and if not in default of the lease, tenant receives a full refund of tenant's security deposit and owes no additional rent. This situation would occur only under extreme circumstances. With the humidity present in Florida's climate, mold and/or mildew can present an issue. It is the tenant's responsibility to ensure that the property is not presenting a condition conducive to mold growth. If tenant's actions or inactions are leading to such an environment, landlord may terminate the tenancy and tenant is responsible for damages caused by mold and mildew. Details on preventing mold and/or mildew growth are provided at the conclusion of the lease agreement. Tenant agrees to reimburse landlord promptly for any costs incurred that are caused by negligence or improper use on the part of the tenant, tenant's family, or guest. Tenant will not hold landlord responsible for any injuries or damage to persons or property that are the result of acts, omissions, or neglect by tenant or tenant's family or guests. The agreement is the lease in its entirety, as there are no other agreements, written or verbal, other than those in the lease. The lease agreement cannot be changed without a written agreement signed by all parties to the lease. State law requires that the radon gas notice be made a part of all leases. To our knowledge, Full Service Property Management has not encountered radon gas in any of our rental properties. However, if you would like more information, we will be happy to provide further details. Additional stipulations are included and commonly consist of a requirement for carpet cleaning and lawn watering. If carpet is present in the home, tenant is required to have carpet cleaned by a professional carpet cleaning company upon vacating the property. Tenant must present the paid receipt to Full Service Property Management at the time of move-out. Renting a carpet cleaning machine will not fulfill the carpet cleaning requirement. Any of the stipulations to the lease will also be included in this section. The signature page typically follows the additional stipulations, but is not the last page of the lease. As implied, the signature page requires each party's signature. As mentioned previously, witnesses to the signatures are required if the lease is for greater than 1 year. The mold addendum is usually a 2-page addendum. It begins by defining mold and progresses to listing ways to prevent mold growth. By initialing the bottom of the addendum, tenant agrees to the bulleted items. Although the list may seem large, The majority of the items are common household tasks that tenant already performs on a regular basis. The addendum goes on to define the items that need to be reported to Full Service Property Management in writing. For removing small areas of mold, tenant is required to follow the directions in the addendum. It is vital that tenant assists landlord in preventing mold and removes small areas of mold as they occur. If landlord has permitted pets, the next page of the lease agreement will be a pet addendum. This addendum describes any fees and/or deposits required by landlord. Each pet allowed on the premises will be described in the pet addendum as well. Payment plans or additional addendums that are relevant to the lease will follow the pet addendum. As these are not common, Full Service Property Management will not discuss them at this time. If you have any questions regarding any additional addendums relevant to your lease agreement, feel free to contact Full Service Property Management. Full Service Property Management is aware that a lease agreement can be an overwhelming thought. However, keep in mind that the lease is meant to spell out all expectations in order to avoid any disputes in the future. It is vital that all parties to a lease understand the terms and conditions of the lease and are willing to fulfill those terms and conditions. All of us at Full Service Property Management strive to make every rental experience a positive one. We strive to keep everyone informed through open communication, as that is the best way to avoid any difficulties. We ask that all parties to the lease work hard to fulfill their obligations. This makes for a smooth, positive experience for everyone. As mentioned previously, each lease is written by a law firm specializing in property management. This ensures that leases are updated as new laws, precedents, and recommendations are developed. At this time, there are a few items that have been added to the lease agreement and need to be brought to your attention. As is the case with pets, no aquariums are allowed on the property without prior written consent from the landlord. Again, we strongly urge tenant to secure insurance for personal property. This is extremely important as landlord is not responsible for damage to or replacement of any of tenant's items that may be damaged for any reason. This includes the loss of food in the event of a refrigerator or freezer failure or defect, or electrical failure. Also, please be aware that tenant is responsible for any cost related to the installation and/or maintenance of phone lines, cable lines, outlets, and/or jacks, if tenant chooses to have such utilities. Finally, there are a few items of vital importance that warrant being restated. Rent payments are expected to be paid in full and on time, and late fees are due if rent is late for any reason. It is tenant's responsibility to make sure the payment is in our office by the due date. Our office is closed every Sunday and on major holidays, so be sure to make the necessary plans, as we do not have a drop box. The property is expected to be maintained at all times by the responsible party, either landlord or tenant, as described in the lease and resident handbook. Pets, permanent or visiting, are not permitted on the property at any time for any reason without prior written permission from the homeowner. Again, we strive to ensure that this rental experience is a positive one for all parties. We have found that when everyone is informed, we can make that happen. Please feel free to contact us anytime.